So let's talk about the title of this video. Can a juror from a previous trial join the defense team and say, hey, well, hello everybody, and welcome back to Buckle Up, It's the Law. Today, folks, we are going to be talking about one of the most interesting changes that has happened in the Karen Read case in most recent times. Something so unique, so crazy, so unprecedented that I don't think anyone has ever seen before. I have never seen it in my career. I have never seen it in my colleagues' careers. I have never heard about it in a different country. I've never heard about it here in the United States of America. And of course, I'm talking about a juror from the first Karen Read trial, who also happens to be a labor and employment attorney. As some of you who have been following trials for quite some time, you may know that typically lawyers don't get picked as jurors. Even though we do get summoned to jury duty just like anybody else, we're not special, we're not different. We get summonses from time to time. I have friends, I had law professors who had served on juries. It's not uncommon, it's rare, it's fairly rare, but more often than not, a lawyer may end up on a jury if each side thinks the other side is going to strike them. So for instance, my torts professor back in law school, I can tell you, stated how he, at the time where he was a law school graduate and an attorney, he was picked to be on a jury. And of course, he ended up being the foreperson because he was actually our torts professor. And torts are, for those of you who don't know, it's when you commit negligence against someone else in various aspects of everyday life. For instance, car accidents are the most commonly known tort, personal injury, which, by the way, is a great time to plug in my firm. We also do car accidents and other types of personal injury, dog bites, etc. If you or someone you love has been hurt, call us 1-844-774-HURT. Now, back to the video. So, our torts professor ended up sitting on that jury because both the defense and the plaintiff thought that the other side was going to strike him. The plaintiff was certain that the defense was going to strike Professor Jones, and the defense was certain that the plaintiff was going to strike Professor Jones. And in the end, neither side struck him, and he wasn't struck for cause, and there was no other preemptory remaining, and he wasn't a random, and he ended up sitting on the jury. And like I said, naturally being selected as the foreperson because, for very obvious reasons, he was the best person for that in the room. He was the best person to articulate what a tort is, because I believe that case was some type of tort. It was some type of personal injury. I don't remember. This is like 20 years ago, maybe even longer. Regardless, attorneys sometimes do get chosen to sit on a jury. For instance, just last week, we had a jury trial and we got a not guilty verdict. Woohoo! Congrats, team. As we were sitting there picking a jury, there was a woman that appeared awfully uncomfortable to be there. And I thought, you know, it's jury duty. A lot of people are going to appear uncomfortable. Come to find out, she actually asked to approach the bench if that was okay. And she said, I'm actually a local attorney here in town. I didn't recognize her. She does mostly business litigation, so it's completely outside any arena I have ever encountered in my career, for the most part. And she said that, oh, by the way, Larry, I want you guys to know, looking at me at the prosecutor, I'm an attorney. I don't know if you guys want to do anything about that. And I was like, I don't care. In my head going, I want you on this case. Like, this is a very, very good case for her to sit on. It was a one-issue case. And so, unfortunately, she ended up either getting struck by the prosecution or she was selected at random when we needed to dwindle our way down to our 6 jurors. So, again, to be called to jury duty as an attorney, extremely not uncommon. To be selected as a juror as an attorney in a jury trial, doesn't matter if it's civil or criminal, not uncommon. Clearly, it happened in the first case. She never got a chance to deliberate, unfortunately, but we'll get to that in a moment. And now, she is part of the defense team. She is going to be acting as a jury consultant for David Yannetti, Alan Jackson, Liza Little, and Robert Alessi. Now, talk about explosive. So let's talk about this woman. Her name is Victoria Brophy George. She is a labor and employment attorney in Massachusetts. She works for a firm called Morgan, Brown, and Joy. She has joined them as an associate. She earned her Juris Doctorate from Northeastern University School of Law, and her bachelor's she got from Princeton. So she sounds like a tough cookie. MBJ call themselves one of the largest management-side employment law firms in New England, representing a wide range of Fortune 100 corporations, not Fortune 500. So they are a very, very large and prestigious firm to represent Fortune 100 companies, educational and healthcare institutions, and other small businesses across all sectors of the economy. The firm's attorneys, which includes Ms. George, the former juror in the Karen Reed case, are known for anticipating and finding solutions to the ever-expanding range of employment-related legal issues in order to avoid the time and cost of litigation. When litigation becomes necessary, the firm aggressively defends its clients and has a proven record of success. And that last phrase also applies to our firm, so that's lovely to see that we are not alone who provide quality, aggressive representation for their clients. According to the MBJ website, she joined the firm on June 1st, 2022 as an associate. However, she has previously worked for them as a law clerk before and after the pandemic started. According to our close connection, Turtle Boy, he has informed us that Ms. George has been randomly selected after she has been picked to sit on the jury with all of the other alternates. As you understand, for those of you who don't, let me explain it. Trials that last such a long time, and the previous trial lasted about 9-10 weeks. If you just pick 12 jurors, and God forbid something happens to one of those jurors, and you're down to 11, you have to declare a mistrial, and you have to start everything over. Kind of like we're doing here, but over there, at least the mistrial came at the end of the trial, not before. And so, in order to avoid that, judges in big cases will oftentimes pick 14 or 16 or even 18, just in case if a few drop out here and there, we have somebody at the end. However, the problem with the Karen Reed case was that Ms. George has been making faces as she was listening to the testimony, not because she wanted to, not because she intentionally wanted to draw attention to herself. Ms. George, all she wanted to do was sit there and eventually deliberate on the case. But she was so utterly disgusted, says Turtle Boy, by the testimony of the police officers, she found it so irritating and non-compelling that she simply couldn't help but show her disgust as she's listening to the police officers testifying for the duration of the Karen Reed case. As a result of that, at the end of closing arguments, when the jury is getting ready to go back to deliberate, her number was randomly selected and she would not go back to deliberate, and her duties as a potential deliberation juror were released. And that is it. Once you are not selected as a juror to deliberate, the case is over and you go home. Turtle Boy also reports that she appeared visibly upset that she had wasted 3 months of her life while she was pregnant, on top of everything, only to have no say in the verdict. On the second day of deliberations, mind you, she even wore pink to the courthouse to protest the fact that she was not able to be selected as a juror on the case. She was absolutely 100% a not guilty vote, as it appears from the evidence presented. Turtle Boy reports that she was a firm not guilty voter and would have used her persuasion skills as an attorney to get more jurors like Ronnie to see the light. Ronnie, you may remember, he was a juror that did an interview and explained the breakdown to Boston 10 News, and he also came on Turtle Boys. Although it is unlikely, Turtle Boy continues, that Ms. George will ever step foot in the courtroom during the trial, her insights as a former juror gives her invaluable insight, and she's quite possibly the greatest jury consultant that a defendant has ever had. And you know what, ladies and gentlemen? I do not disagree with that statement one bit. So let's talk about the title of this video. Can a juror from a previous trial where they didn't even get a chance to deliberate, or let's say, what if they did? Can they now join the defense team and say, hey, I want to help you guys out. I was there. I listened to everything. There are no laws or rules of any kind to either permit or restrict such conduct. It's a free-for-all. If a juror from a case wants to come forward and say, hey, I have information for you. Doesn't matter who they are. She didn't have to be an attorney. She could have been an engineer. Could have been Ronnie. Ronnie could have joined the defense team. There is nothing legally that Auntie Bev or Hank can do to stop Ms. George from helping the defense. From a legal perspective, everything that is happening is, although so unorthodox and so unprecedented, as so many things have already been in this trial, regardless, setting that aside for a moment, there is no reason for her not to help them. And she has the power to provide information that is so critical to the defense because she sat there and listened. She knows the weaknesses of the case. She knows the strength of the case for the defense and the prosecution. She can pinpoint arenas where she was like, I didn't even care about this. You can skip that. I don't think anybody would care about this information. As I'm sitting there listening, I'm going, why are you hammering this home so hard? Like the cell phone data, for example, with Lieutenant Tolley, which by the way is a series coming up on this channel. She may provide them with insights beyond human comprehension because she got to sit on the other side and listen for 10 weeks straight to testimony. And that is unprecedented. That is huge. That is one of the most incredible things I have ever seen happen in any trial ever in the history of all courts in the United States of America or elsewhere. I don't think this has ever happened, and I doubt it will ever happen again because so many things have to fall into place in order for it to happen. First of all, you have to have a trial number one that ends in either a mistrial or some sort of no verdict situation. You also have to have a juror that is ready, willing, and able to come forward and say, hey, I want to talk to you. And there's a retrial, so the case doesn't settle. I mean, so many things have to happen. This combination of things is so rare. I mean, just prongs 1 and 2. In my entire career, I have only had 4 instances where a mistrial was declared for various reasons. Either a cop said something improper, a lawyer said something improper, a jury couldn't decide, etc. And I can tell you in every single instance, we either settled, 3 out of those 4 cases settled in favor of us, and 1 case went to trial, and unfortunately we ended up losing. These types of trials, when a case goes back to trial on a mistrial, are even rarer still. Out of 50 jury trials, I had 1 case that actually ended up going forward. Think about it. That's 2% of my entire docket that went to trial. And only 2% of cases end up going to trial anyway. So think about it. It's 2% of 2%. It is a fraction of a fraction of a fraction. And on top of that, how many trials are publicized? That's another 2%. You got 2% of 2% of 2% of cases. This is such an anomaly. This is such a unique situation. It's insane how cool this is. We are witnessing history in the works, and I cannot wait to see what Ms. George has to offer to the defense that they're going to be able to use in trial number 2 in order to finally get that not guilty verdict for Karen Read. Bye, everybody.